Thank you for joining Quick Tips for Nonprofits. In today's Quick Tip, we will discuss conflicts of interest. Community Law Center is a legal services provider for nonprofit organizations and community organizations throughout Maryland. Community Law Center can help nonprofits with a variety of legal issues such as formation, necessary filings, and governance for boards, to many other issues involving property, zoning, contracts, employment, nuisance issues, liquor board matters, and intellectual property. Today's Quick Tip is just for informational purposes and should not be construed as legal advice, which really should be tailored to your organization. If you wish to become a client of Community Law Center, your organization can submit an application. Conflicts of interest is a topic that's been in the news a lot this past year. Because of the high degree of public trust associated with nonprofit organizations, it is especially important for nonprofits to be familiar with and navigate this area well. What is a conflict of interest? A conflict of interest is a transaction or arrangement that benefits the private interest of a key individual of the organization, such that the individual is prevented from being impartial and loyal to the organization, or which might result in an improper excess benefit. A conflict of interest occurs where individuals' obligations to act in the organization's best interest is at odds with their own financial interests, and that can be either directly or indirectly. Examples might be the director of an organization receiving significant gifts or perks, or giving corporate opportunities to relatives, or using the organization's assets for personal gain, or if a key decision maker in the organization were to set their own salary. Just having a potentially conflicting financial interest is not always illegal or improper, but it's the manner in which the director and the board deal with the issue that can determine the propriety of a decision or transaction. We mentioned key individuals, but to whom exactly do conflict of interest considerations apply? It's anyone involved in controlling the organization. So this includes for sure your directors and officers, but also committee members if there are any that the board gave some authority to, and perhaps also key employees depending on the organization. So if any such person has a financial interest as defined below, they are what we call an interested person. And financial interest means either directly for themselves or indirectly through business, investment, or family. And some examples would be if your sister is the owner of a vendor that your organization is using for an event. Or instead of sister, it could be a different relative, or someone that you're in a significant business relationship with. Another example might be if you're being paid by a company that your organization hired, or if a company that the organization is negotiating a transaction or arrangement with sends you, or someone else that we mentioned before that in relation to you, a significant gift which is beyond typical small business courtesies. You need a way to avoid actual or even perceived private benefit to individuals that are leading the organization, which is what a good conflict of interest policy provides. It's a set of procedures that will protect the organization and hopefully prevent charges of impropriety against your officers and directors. These are the important components to keep in mind for any conflict of interest policy. There's disclosure, an independent discussion and independent vote, and also proper record keeping. For disclosure, whenever anyone in a position of control in your organization has a potential conflict of interest that affects them directly or indirectly, they must disclose that interest, including all material facts, to the board of directors in a timely manner. People may simply be unaware that their personal or family activities may be in conflict with their duty to look out for the best interests of the nonprofit. So do make sure that all key members of your organization know what constitutes a conflict and that they must disclose all potential conflicts. After disclosure, there must be an independent discussion and vote. So the potentially conflicted member must leave the board meeting, and the remaining board members would discuss the issue. And they would investigate alternatives when appropriate, such as doing your due diligence, for example, to compare prices from other vendors. These board members must also then determine what is in the best interest of the organization and take a vote. In some cases, it may turn out that the potentially conflicting transaction or arrangement is not a conflict and is fair and reasonable, and maybe even is the best option. Remember that you do need to record this procedure that was followed into the board meeting minutes. For the record, you want to include, for the potential or actual conflict of interest, who was it that had the potential conflict of interest? What was the nature of the financial interest? And what were any actions taken deciding on the conflict? And what was the board's decision as to whether or not a conflict of interest in fact existed? And on the discussion and vote, who was present for the discussion and votes? What was discussed, including any alternatives to the proposed transaction or arrangement? And do record any votes that were taken. Remember, everyone who is in a position of control within your organization should understand and sign your conflict of interest policy on a regular basis. Thanks for checking out this quick tip. Please visit our website, communitylaw.org, to see our workshops, watch more quick tips, and access helpful publications for nonprofits. You can also sign up to speak with an attorney for free, or you can apply for services to become a client of the Community Law Center. Thanks. Take care.